must be reflected in the special rules. And then the resolution must comply with Section 12.2 of the Act, which state that it must be submitted within 60 days after passing of the resolution. If that requirement is not met, we can raise certain queries and ask that a new resolution be submitted to comply with that requirement of Section 12.2. And then also the certification in terms of Regulation 18 must be stated, which reflects then the commencement date of the participating employer in the umbrella fund. We also require that the special rules have a certification which states certify that the above resolution has been adopted in accordance with the provisions of the rules of the fund. The document must also be signed in terms of Regulation 20B by the principal officer, chairperson, and one of the trustees who are currently on the board of the fund. And then in 2020, the authority issued FSCA information request 3 of 2020, in which we requested certain information to be provided when a fund submits special rules to us for consideration. If it is a set of new special rules, Annexure B must be submitted, and we ask certain questions relating to the nature of the fund of the participating employer. So with each new application, Annexure B must be submitted. When a participating employer has been registered in terms of special rules and they want to amend the name of the fund, the name of the participating employer, sorry about that, they also will have to submit Annexure C in that regard. It's just for us to have a paper trail of the names of the participating employers and how they've changed. Then once special rules have been registered, the effect on the participating employer is that the participating employer and members' rights, powers, responsibilities, and obligations are governed by the rules of the fund. So special rules will have to be read in conjunction with the main rules of the fund, especially where the special rules may refer that the benefits is in terms of rules 1.1, say for instance, of the main rules of the fund, where the main rules will indicate what the benefits will be. But most special rules will indicate the contributions by the member and the employer, and then any benefits payable in terms of that special rules. Yeah, that's very short and sweet on special rules. I can just add, once a set of special rules are registered and the fund intends amending a registered set of special rules, they can do it via revised special rules. So the fund can amend the contribution rates, increase them, can change the benefits, all that kind of stuff, and we require that it must be done through a set of revised special rules, and that set of special rules, revised special rules, must also comply with Section 12.2 of the Act and must be submitted within 60 days of passing and adoption of the resolution. We're gonna consider deregistration of participating employers now. Information Circular 2 of 2017, sorry about that, was issued in July 2017 to give guidance on how participating employers should be deregistered. In that information circular, reasons were provided on how participating employers will deregister. It will be in terms of section 14.1 or a 14.8 transfer. The last member has exited due to retirement or benefit being paid out, where a set of special rules have been registered, but the participating employer never commenced participation in the fund. In other words, the administrator never received any contributions from the participating employer, and such the participation never commenced. And then exemption in terms of section 28 of the Act. Information circular. The information circular gives certain requirements on documentation that needs to be submitted to us. This one deals with section 14.1 and 14, sorry about the typing error there, 14.8 transfers in terms of the Act. There must be a completed Annexure B submitted, a declaration by the chairperson in the form of Annexure 2, any disclosures, the form G in terms of Directive 6. If it was a section 14.1 transfer, we need the case number, and approval letter can also be submitted. If it is a section 14.8 transfer, forms H and J must be submitted. And then we also require a resolution for the termination, for the cancellation of the special rules for the relevant participating employer. And then we also do an investigation to see if there's any surplus apportionment schemes done on the fund or the participating employer, to see that it complies with minimum benefits. When it comes to last member exiting the fund, information circular also, the information circular also has some.
Johan?
Yes.
Sorry, Johan, before you continue, there is a hand from Prudence.
Okay, thank you. Thank you, Prudence.
Nandi, can you unmute Prudence, please?
Good morning, everyone. Johan, I just wanted to add something on the termination in terms of section 14. So we do have instances whereby the reason for transfer does not fall under section 14 subsection 1 and 14 subsection 8, but the transfer is within the umbrella arrangement. So in such instances, we have additional requirements. So we require that all the documents that are currently prescribed in the information circular be uploaded. For instance, the declaration by the chairperson, but we also require that a declaration by the fund's financial accountant and by the administrator be submitted, including also the statement confirming the zero assets in terminating PE. What we also require is that there must be a resolution, and this resolution must reflect both the participating employer's details, and then it must also contain an explanatory statement reflecting what necessitated the one employer transferring to another. And then what we also require is that there must be a confirmation by the principal officer. So yeah, that's it.
Thank you so much for that, Prudence.
Yeah, thank you, Prudence. Thank you very much for that. Julia, I just want to confirm, can the delegates still see my slide?
Yes.
Okay, wonderful. Thank you so much. Then the requirements in terms of information circular 2, when it comes for the last member exiting, it's also Annexure B must be submitted. The declaration by the chairperson in the form of Annexure C3, proof that the last member was paid and the participating employer has no assets and liabilities. And then like previous stated, also a resolution, and then we'll also do a further investigation to see if a surplus apportion scheme was done on the fund or the participating employer. Then the requirements of Information Circular 2 when it comes to participation never commenced. We also require Annexure B. Then we require 2 declarations, one by the chairperson in form of Annexure C4, and then a declaration by the participating employer that didn't commence, also in the form of Annexure C4, and then also a resolution for the cancellation of the special rules for the participating employer. And when it comes to Section 26 exemptions, I know in the previous session, in the next session, 2 of my colleagues will be discussing the requirements regarding liquidation and termination of participating employers. But when they completed their process, what we require is a declaration by the chairperson in terms of C6. It will be completed by him and the responsible person for winding up of the participating employer, and also a resolution requesting that the special rules be retracted. Just a general comment on submission of applications to terminate or deregistration of participating employers.
Sorry, Johan, before you move.
Yes.
Okay, there was a hand. I think
okay.
maybe they just lowered their hand. I think they wanted to speak to the last slide or the previous slide.
Okay.
So but they just lowered their hand. So I guess you can continue.
Okay. Yeah, no, we will keep maybe that they will ask that after this presentation, then we can just
All right.
address any concerns or questions on that. But like I was stating, when administrator or fund uploads application for deregistration of participating employer, we just require that a formal covering letter also be submitted, just to state that this is like just a formal covering letter, and then the subsequent Annexure B and all the supporting documentation to that, and then the application will be processed. The effects of deregistration. The authorities then shall terminate the participating employer on proof on the documentation, and that we are satisfied that the employer has no assets or liabilities and has exited and ceased to exist. The principal employer, upon termination, shall no longer participate in the fund, as there will no longer be any special rules pertaining to the participating employers. No contributions will be made to the fund by either the employer or its members. No benefits will also be payable. No funds can be transferred in and out on behalf of the participating employer, and the participating employer will become inactive. And on our systems, it will reflect status as cancelled. In other words, yeah, there's no more participating in employer. Then I just want to highlight few issues, not issues, FSCA experiences, especially when it comes to special rules, and then the suspension and reduction of contributions. Special rules must be amended timeously via revised special rules for any suspension or reduction of contributions. Such applications must be accompanied by the employer instruction relating to the suspension or reduction, and then member communication, as members need to be aware of any suspension or reduction to their contributions. And any such period may not exceed 12 months. When the COVID pandemic arose, the FSCA issued FSCA Communication 11 of 2020, which provided guidelines on this during the COVID-19 pandemic. And we received numerous applications on that. And yes, so the guidelines are provided in that communication. When it comes to the deregistration of participating employers, one thing that we've noticed, especially when it comes to participating employees who never commence business, we require 2 Annex C4s, one by the chairperson of the fund and the participating employer. It seems that there was a bit of confusion under with certain funds that they only can submit 1, but we require both those Annex C4s when it comes to the deregistration of a participating employer where it never commenced business. And then a duly signed resolution is required when it comes to a type A umbrella fund. As stated in my previous slides, on all four reasons for determination or deregistration of a participating employer, we require a signed resolution requesting that special rules for the participating employer be cancelled. And then on type B umbrella funds, we do not require such resolution, as there are no special rules applicable to that participating employer. Thank you. It was a very short and sweet presentation. Is there any questions from delegates? Thank you.
Yes, thank you so much, Johan. We do have a couple of hands before we even go to the chat box. There's a question from Jaya.
Hi, thanks, Julia. And thank you, Johan. Can you hear me?
Yes.
Yes, I can hear you. Thank you.
Perfect. Thanks so much. I had a query about paid up members in umbrella funds in instances where the employer is either transferred out or is being liquidated. And those paid up members are obviously not transferred along with the active members. In line with Regulation 38 and the legislative intention for there to be default preservation, are funds able to liquidate or deregister a scheme within a fund while maintaining those paid up members in the fund, perhaps in a separate section?
I think that is a question better answered by the surveillance Retirement Fund Prudential Supervision division. But according to me, when a fund transfer, everybody must transfer out. A fund cannot just consist of paid up members. I had a previous one where it was referred to SART, and they had a concern that the main purpose of a fund is to receive contributions. So if that is taken away, what's the purpose of having that fund or participating employer? But yeah, for me, if all the members must be transferred out, the fund cannot just consist of paid up members. If that answers your questions.
Well, just to clarify, so if an employer is transferring to another umbrella fund, for example, usually an umbrella fund won't accept a transfer in of paid up members, only active members. So the only option left if everybody has to transfer out would be for the paid up members to then transfer to a preservation fund, which is obviously possible if that's what you're saying is necessary.
Can I ask you a favor? Is it possible to just put your answer in an email and then we can transfer it to our Section 14 department who deals with transfers? Mamiki. I think that yeah, she will be in a better position to ask you when it comes to transfers of participating employers, if you don't mind.
Sure, that would be great. I'll email you. Thank
Okay,
you.
cool stuff. Thank you. I'll put yes, thank you.
Okay, thank you so much, Yara. There's a question from Mandla.
Julia, it seems like his hand disappeared.
Okay. Merle. Merle.
Yeah, Mandla is back, but we'll just quickly speak to Merle. Good morning. Merle, just unmute.
Yes, could the delegates please unmute themselves?
Sorry, yeah, I had to look for the microphone. There are quite a few on my screen. Good morning, everyone. I'm Vollenhoven. I've been doing a lot of these submissions for cancellation of registrations, and the point that Prudence made earlier about internal transfers is very valid for us in terms of the fact that they are not either Section 14(1) or 8 type transfers. So we actually had a query internally on how to handle those. Is there going to be a communication, or is there any way of getting those requirements that you mentioned earlier, communicated to us in writing? Because that is quite valid where it's an internal transfer within the umbrella fund between participating employers. That's my first question. I have another, if that will be okay.
That's fine. I quickly, yeah, I'll just answer on the quick one. I think it's something that we can consider, but I'll just need to discuss that with my fellow colleagues on that. But it's something that we could maybe look at, and yeah, we'll let you guys know. Thank you.
Great, thank you. Because yeah, it's an ongoing, and different funds treated differently, so it would be good to get a good idea of what your expectations are. And then I picked up on the FSCA experiences slide where you referred to FSCA Communication 11 of 2020, the guidance for the special rules. It's not really my area, but I just had a question from a consulting point of view. Would FSCA Communication 11 of 2020 still apply for employers in financial distress? Because I picked up something that the earlier speaker raised about process and options available to employers in distress. So is it allowed? Because as far as I know, because COVID is now over, there was an expiry period, basically when the COVID ban or whatever it was, the lockdowns were lifted. So that just kind of intrigued me.
Hi, yeah, thank you for the question. Now, that communication was actually just issued for COVID-19 situations where participating employees were in financial distress. So if a participating employer is in financial distress, it won't be considered in terms of that communication, but we will consider such applications if there's valid reasons for that. But that information was only given for COVID-19 related issues.
Specifically, but we can use the guidance from that process note.
I think you can use it maybe as a guidance, but you can't rely on it.
Right.
Currently, it was only for that specific, yeah, because you can't, because I'm going to put this: the COVID situation is already over. If you know what I'm trying to say, so so that communication was only issued for that specific scenario. But you can use it as sort of a guideline, but you can't use that information circular for distressed participating employers.
So it's for
Because
consideration.
yes.
Thank you.
I hope that answers your question.
Yes, absolutely. Thanks so much.
Okay, cool stuff. Thank you.
Okay, thank you so much, Marilee. We'll just take 2 more questions from Mandla, and then from there we'll take a question from Nesli. Mandla.
Thank you, Johan. Sorry if this was covered. I just have a question around companies within one group of companies, each being responsible for making employee contributions. Must each of those companies have their own special rules, or can they all operate under one set of rules?
Currently, every participating employer must have its own set of special rules. We're not gonna short and sweet. Each participating employer must have its own set of special rules. So we're not gonna currently allow umbrella within an umbrella. So each participating employer must submit its own set of special rules.
Thank you.
Okay, cool stuff. Thank you. And I think then the last question from Nasli.
Nesli.
Yes.
Thank you very
morning.
much. Good morning, Johan. How are you?
Good in yourself?
Good, thank you. Good, thank you. Johan, we administer industry funds, and in some cases, not very compliant industry funds, where we're struggling with participating employers who are non-compliant. My question is, in terms of the exits process for the fund, we have obviously an employer stamp and signature that's required to exit the member. In many cases, we're busy with an exercise at the moment where we're trying to establish whether or not the employer is operating. And in many cases, we're seeing that on the CIPC or the BIS portal, it says that the employer is in deregistration, but that can take up to 7 years, right? They're in deregistration, but the employer is still operating. In that instance, and we can't reach them. They're non-compliant. They don't want to pay contributions. They don't want to be held to account. What is the recourse for funds and administrators? How do we deal with it? Because even as a legal entity, they're in trouble or non-compliant. So from a deregistration point of view, cleaning it out and getting rid of the employer in the fund, we don't just want to terminate their participation. I note that all members have to have left the fund in terms of the circular of 2017. But if we can't get the employer to sign and stamp the claim forms, as the fund sign in the employer's stead, number one, and then do we just pay all the members out, irrespective of the fact that we're still waiting for contributions?
Sure, yeah, that's a very, very complicated question. It sounds like there's a lot of things going on. Because that's the thing is when participating employees don't contribute, that's now a 13A issue. So there's a lot of factors at play. Because we can't just cancel a participating employer just on a letter. We need all that information to cancel participating employer. So I understand where the difficulties come in, where you can't get hold of the participating employer, or he's gone, or it's I understand your frustrations. That is a bit of a difficult question. Can I ask you as well, just formulate that into an email from me, and we will give you some guidance on how to proceed with those situations.
Thank you so very much.
So there's a hand from Ms. Letele. Gloria?
Thank you, Julia. No, this is Gloria from FSCA. I wanted to have clarity as to what exactly does Nasli says, because at some stage she says they know that the employer is still operating. And if they know that the employer is still operating, what, make them unable to go to that employer and get whatever documentation they want?
Thank you. Can I respond?
Yes,
please.
Natalie.
Thank you, ma'am. So when we say we're aware that the employer is still operating, we administer funds where employers work out of their boots of the car. So there's no fixed physical address where we can reach the employer to say, okay, your CIPC status says you're in AR deregistration, but we've had a couple of people complain, members come forward and complain that you're not contributing to the fund, but there's no fixed physical address. So we trace the employer, we get contact details for the directors, call them. They tend to block our numbers. They know our 011544 number. So they don't engage us because they're non-compliant and they know that they owe the money that they're deducting. But through members, to answer your question, through members that complain about non-contributions, we are aware that the employer still runs some operations somewhere in the country.
Okay, no, I get it. The problem is where you are being blocked, and obviously, if he is operating from the boot, you wouldn't know where exactly or at that particular point of time is the employer.
Yes.
No, and okay, no, I just wanted some clarity on that. Thank you.
Thank you, ma'am.
Thank you so much. Ladies and gentlemen, it's 11:50 and was according to the agenda. We're supposed to be taking a break. Thank you so much, Johan. We've noted some of the questions in the chat function, so we'll just deal with them during our Q&A. But for now, I think we should break until 12:15.
Thanks, Julia.
Welcome back, ladies and gentlemen. I hope you had a great break. Our last speakers for the day are Floyd Mabena and Mr. Ezekiel Raseroka, both of whom are specialist analysts within the Retirement Fund Supervision, a Prudential Supervision Department at the FSCA, and they will provide a summary of the liquidation process and touch on arrear contributions in relation to liquidations. Without wasting time, I'd like to call Mr. Mabena and Mr. Raseroka into the virtual stage. Kia, can you share the presentation?
We forgot to tell them not.
Thank you.
Yes, good afternoon.
Mr. Mabena?
No, it's Ezekiel's. Okay, good afternoon. My name is Ezekiel Raseroka from Retirement Funds Prudential Supervision. I'll be...
Mr. Raseroka, I can't hear you. Am I the only person?
Can you hear me now?
Yeah.
Yes, I can hear him.
Oh, sorry, I was on mute.
Okay. Yeah.
No, we can hear you, Julia.
Yeah, like I said, my name is Ezekiel Raseroka from Retirement Funds Prudential Supervision. I'll be dealing with the liquidations of pension funds and participating employers. And my colleague Floyd Mabena will be dealing with exemptions in terms of Section 2817, which exempts funds from going through the normal liquidation process. Without further ado, we can go to the next slide. Yes, the slide provides the generic definition of a liquidations, which talks about the process of bringing a business to an end and distributing assets to claimants. So you'll notice that with regard to pension funds or participating employers, it's actually the distribution of benefits to members and subsequently terminating the fund. Yes, the slides is panel of approved liquidators for retirement funds. So the authority keeps and maintains a list of all approved liquidators, and it also says that no person will be allowed to act as a liquidator unless of a fund or participating player unless he or she is approved by the authority. And what will happen is that for a person to be on the panel of liquidators, he must submit an application to us in terms of Directive 4. So, and among others, the documents that he must submit is Form A plus the following. He must provide us with a copy of his curriculum vitae, copy of qualifications, and something that is not there also is a professional membership. Like he must be a member of a professional body. For example, if he's an attorney, he must be a member of the Law Society of South Africa, or if he's an actuary, a member of the Actuarial Society of South Africa. And the person must also have a professional indemnity insurance policy and also provide us with a police clearance certificate. And also a credit record. So the liquidation process, normally we deal with in 4 phases. The first phase being the application for liquidation, application to advertise, application to pay the benefits, and eventually the deregistration. So the first, which is the application for liquidation, is actually the initiation of the liquidation process. So the fund will normally submit a board resolution, which will have a Form B, the board resolution which should be duly signed, and Form B and Form C. So Form B normally gives us information on the fund, and the Form C will give us information on the liquidator, which we will also describe or tell us if he or she is independent. Once the liquidator, from this process, the liquidator will be appointed or is appointed, will be rejected. But once he is appointed, we expect the liquidator to provide us with the application to advertise. And what is in the application to advertise will be the preliminary accounts. Preliminary accounts consist of Annexure A, Annexure B, and Annexure C. So briefly to explain the annexures, Annexure A will normally be based, I would say it will be assets and liabilities based on the latest set of financial statements of the fund. And Annexure B will be the information, the financial information as at liquidation date. That is the date on which the liquidator was approved. Because he must be approved by the FSCA so that he can be a liquidator of a pension fund. And Annexure C will give us the distribution list of benefits as they will be paid to different members. The third phase will be application to pay, because at this point we have, after reviewing all those information provided, will give the liquidator an approval to advertise. So once the accounts will be advertised, and the accounts will be advertised for a period of 30 days, and after 30 days, the authority will give 14 days on which members or interested parties can make objections. And after that, the accounts will be, how are they going to be advertised? They should be advertised in a government gazette. They should be in the newspaper, in one newspaper, and also in the magistrate court. In the magistrate court is when the registered address of the fund is not in the same area as the authority. So if the registered office of the fund is outside the area of the authority, then we need that he must provide us with proof that the accounts have been placed at the magistrate court and are stamped for proof that they were. And also they must submit the proof of payment of the FSCA fees. Normally the fees are based, it will be 20% of the liquidation fees. And eventually the liquidator will go to the deregistration phase, where they will provide us with the final accounts. And once we are happy with the final accounts, because final accounts will be after they have paid all the benefits, will reflect to us that the members have been paid, and now we can deregister the fund. Next slide. Yeah, for the fund to be liquidated, normally the fund will be terminated in terms of the rules of the fund. So the trustees will appoint a liquidator in terms of the rules of the fund and apply online to the FSCA for approval. So they'll normally provide a board resolution from B and C, as I indicated in the previous slide. And also the Pension Funds Act provides that for the liquidation of a fund in terms of Section 28(1) of the Pension Funds Act. And also the Section 28(2) provides the effective date of liquidation, which is actually the date at which the liquidator was approved to act as a liquidator of a particular fund. So before the liquidator is appointed, the board of trustees have a duty of making sure the following are in order. The responsibility of appointing a liquidator, and they must submit an application of such application online for approval to the authority, and that is done online. So we only accept online applications. They must ensure that all statutory submissions are up to date, including financials and valuation reports. They must ensure that the transfers, Section 14 transfers, rule amendments, revised rules have been approved by the authority. They must ensure that termination clauses in registered rules are invoked timely so as not to place the undue waiting periods on members, beneficiaries, and pensioners. They must, next slide. They must inform the members of the impending liquidation of the fund. So, which means before this process starts, they must have informed their members. They must provide all necessary information regarding the fund and its history to the liquidator. They must perform their own due diligence to ensure that all outstanding matters are brought to finality in an efficient and cost-effective manner to ensure that the liquidations run smoothly. They must recover any outstanding area contribution. So once the liquidator has been appointed, he or she assumed the duty of the board. He becomes the board of the fund. So his duties will be as such. He must realize the assets, submit the liquidation accounts, recover area contributions, and pay benefits to members. He must ensure that members are continuously kept up to date with the progress of the liquidation. He must attend to all queries raised by members relating to the liquidation and also inform the authority of any matter that may have an impact on the liquidation while in progress. The last slide deals with the treatment of area contributions or liquidation. So before the liquidator, when they initiate the application to liquidate the fund, in the Form B that they must submit, they must disclose that the fund has got area contributions, so that the authority knows that they'll be dealing with a fund that has got area contributions. And once the liquidator is appointed, when he submits preliminary accounts, he must disclose the said area contributions. And normally, he's got a duty to recover area contributions. So normally we request that the liquidator must give us proof that he has been, what he has done to try and recover area contributions, to show that there's been an effort on his side to recover area contributions. And also his duty bound to open a case with the South African Police Service. And also for that, we need proof that he has done. He's got a case number to prove that he has done that. I'm handing over to my colleague Floyd Mabena to deal with liquidation exemption from the liquidation process.
Good afternoon, everyone. My name is Floyd Mabena. I'll be taking you through the liquidation exemption process. I'm using the same system as Ezekiel because I've got issues with my computer. So I hope you can hear me.
We can hear you.
Thank you. Okay. Section 2817 of the Pension Fund Act provides the authority with powers to exempt a fund or participating employer from going through the normal liquidation process. So what happened is that we came up with Directive 4 to determine the processes and the limits of a fund or participating employer that wants to go through a liquidation process. The fund first will have to trigger the termination or the liquidation clause in its rules before, and the board needs to determine if the fund or the participating employer does comply with point 92 of Directive 4, which is the average benefit per member should be less than 50,000. The number of members should be not more than 50, and the total assets is not more than 50 million. The surplus issues should have already been dealt with before a fund can even apply. Next slide. So if a fund that try to apply in terms of Directive 4, but does not comply with some of the conditions that are on Directive 4, they can apply using Notice 5 of 2003. The notice actually gives the fund a space so that they can apply without having the limits of 50 member or the average of 50,000. So what happens here is that when the fund applies, they also need to inform us in terms of an additional letter that they are aware that they are not complying with Directive 4, but they wish to also be exempted from liquidation. Then they will submit that letter together with Form D, which is used for Directive 4. So in terms of board notice 5 of 2003, the limit is only 100 members. So you can have a participating employer that has 70,000, maybe with 70 members. But as long as your members are below 100, then you will qualify in terms of this notice. Next slide. So there are some circumstances where we will not grant exemptions. If the fund or the participating employer has unclaimed benefits, we won't grant the exemptions. So is the surplus distribution not yet done? And if there are area contributions still in the fund, there will be no. We won't even pen these cases. We'll just reject them, because these three items should have been should not even exist by the time you apply for an exemption. Next slide. So these slides provide the process that needs to be followed when you apply for liquidation exemption. Once the board of the fund, as I said, has triggered the rule, the termination rule, and have determined that the fund can comply with 0.92 of Directive 4, they need to submit a Form D. Form D actually it's a formal template that we have in Directive 4 that the funds can use. You just tell us about the person who will be doing the distribution, the number of assets, just a brief description of what the participating employer or the fund is all about. Once we are happy with your application and we have granted you approval to be exempted, then you need to pay the benefits within the period of 12 months. But then if it happens that you are not able to pay within 90 days, every 90 days, you need to submit us what we call a 90-day report, which is just which is just a progress report that tells us how many members were paid during that period from the day of the exemption and the 90 days, how many members were paid, what was the method of calculation of the benefits, were there any deaths within that period. So Again, every time you have not paid every 90 days, you have to submit this progress report. Once everything has been paid, once every member has been paid, whether before 90 days or after, you submit what we call a Form J, which is a declaration of that the fund has no assets, members, and liabilities. So this stage is not, once this on Form J stage, the only thing that happens is that we have completed the liquidation exemption. It does not necessarily mean that the fund or the participating employer has been cancelled. You still need to move to Section 27, where you submit Form C and the resolution, where the resolution for withdrawing of the special rules of the participating employer. Then after this period, that's when you can say the participating employer or the fund has been the process of termination has been completed. We can move, Julia. So the challenge is that when encountered during the liquidation, so the liquidation and I've combined both the liquidation and liquidation exemption on this page. Most of the issues that we get or receive from the funds when we ask why are they not completing the liquidations is that they struggle to get tax directives for members, transferring of unclaimed benefits to unclaimed benefit funds. They are saying most of the unclaimed benefit fund have conditions on taking up members. So sometimes they don't have the details of the member, and the unclaimed benefit fund will not receive these members. So these members then will stay in the fund or the participating employer that is being deregistered or liquidated. Another issue is the area contributions. The liquidators will try to trace area contribution, make an arrangement with the employer to pay area contributions, which sometimes take time, especially when the employer promised to pay. The fourth one is the opening of a SEP case. We require the liquidators to open a case with SEP when there's area contributions so that they can comply with I think it's Section 13 of the Act, where they have to go after the board members in their personal capacities. The second point, most of the time the liquidators are struggling to provide us with investment growth. So when we do the liquidation, we want them to provide us with a breakdown of the money received or realized, how it's going to be distributed, how much was received, and we normally get issues when it comes to growth. Liquidators normally they want to lump everything up, and it takes time because we have to. It's going to be we have to go back to them. They come back to us. So even this issue, but it's not an issue that you should be worried about, because at the end of the day they will provide us with the breakdown. Then the third one is we get a lot of inconsistencies from when we compare the prelims account and the final accounts. So you'll find that they are not talking to each other. Then again, it will be the process of talking to the liquidator to give us the breakdowns until we satisfy ourselves that the money was distributed accordingly. So for the liquidation exemption, the responsible person who's responsible for winding up the fund of the participating employer, normally they don't comply with the 12-month periods. So some of these funds or participating employer that are exempted, they take as long as the liquidation, of which is not the aim, because we think the liquidation exemption should be simple It doesn't have to take you long. We don't have to appoint someone who's on the panel. We don't have to advertise the account. There's no objection period for members. We don't submit all these documents that are submitted within the liquidation. So it's a bit of a worry that it can take 2 years, 3 years. So we still engage with them, trying to understand, but also they do bring the issue of tax directive and members' details or tracing of members. They can't get hold of members, which does impact in terms of their timing. Next slide. Are we done? All right. It seems like we are done from our side. We can take questions.
Thank you so much, Mr. Raseroka and Mr. Mabena, for the insightful presentation. We do have a number of questions from the attendees. One of the questions is from Nestle, is do Type B umbrella funds need to go through liquidation exemption process?
Yes, only if they comply with the conditions of Directive 4. So they should not be more than 50 members. Those conditions that I've just mentioned.
Okay, thank you so much.
50 members, 50 average per member should be 50,000, and the asset should not be more than 50 million. Or alternatively, they should also apply in terms of the board notice if they have less than 100 members of the notice, not the board notice of the notice.
Okay, thank you so much. There's a hand from, for some reason, I'm not able to see. Oh, there's a hand from Nadia. Nadia, please unmute yourself.
Hi, yes, Sarah, I just want to ask a question. With funds moving between fund administrators changing 13B, we've got pending liquidations where the exemption was granted, but the person responsible is no longer involved with that. How do we wrap that up or change the person responsible for winding down that process just to complete the Form J at the end?
Okay. Yeah, we don't have a prescribed format that you need to fill for that. What happens is that you need to inform us of the new person so that we can record them on our system. Then the new person can sign the Form J with the 13B person.
Okay, thank you. So by informing you of the new person, is it just merely communicating via email, or is there a form or anything that needs to be completed for that?
Preferably a formal letter.
A formal letter just to say that the new...
Submit it online, yeah.
Okay, thank you very much.
Thank you.
Okay, thank you so much. There's a question from Mary Lee. She's asking question, upon liquidation in terms of Section 28, when exemption from advertising is granted, who's responsible to pay the FSCA fees?
The exemption from advertising is granted.
Yes.
The liquidation expenses are paid from the fund. So normally what happens, let's say it's a small participating employer. They will pay the liquidator 2,500, which is the minimum amount. Then the authorities fee is 690. Then if there's no advertising, then we skip that one. But all the money comes from the fund.
Okay, I see Marilyn has got her hand up. Marilyn, please unmute yourself.
Thank you. I actually have an actual scenario where we've been granted exemption and the liquidator told us to pay the FSCA directly. And my thinking is now, after listening to your presentation, I'm almost thinking that the fee would fall away if it was intended for advertising. I mean, am I correct in thinking that? then that small fee that they would have included in the prelims, I mean, do you still not expect a fee from the fund? The provision has been made for it, of course.
Are you talking about where the liquidator applies to waive his fees?
Yeah, no. So the liquidator fee is applicable, but in the prelim, he's made an accommodation for the FSCA fee, or that he calls it still the registrar fee. But we've received exemption from advertising. Our question is, what then becomes of that fee that we've made provision for? Should it be distributed to the members or paid to the FSCA still?
Are you referring to the fees that were saved from not advertising?
Yeah.
No, that money is distributed to the members.
Okay.
It goes back to the fund and distributed to the members.
Okay. Yeah, that's what I was thinking while you were speaking. I realized, but I don't think the liquidator was sure, so at least I can let him know as well. Because I mean, ultimately it is his responsibility though, isn't it? Because he's now actually the board of the liquidation. I have one more question. Is it okay?
Okay.
Thank you. When you talk about the unclaimed benefits on the Form D, you are then saying that it's only where there's still unclaimed benefits left in the fund and that's not been transferred out? Or are you asking us, have we transferred out unclaimed benefits to whatever unclaimed benefit fund we have?
Okay. For exemption, there should be no there should be no unclaimed benefits. So basically, if you are able to transfer them before you submit the application, yes. But to reflect them on your application for exemption, it's going to be rejected.
Well, yes, I had a case like that, but I mean, the money was transferred out. I thought, I don't think we understood that you don't need to mention it if they've been transferred out already. Then is it okay? Sorry, another question.
Yes, okay.
I've had a case with an exemption granted, but relatively new to the process. So it was a group of employees that were terminated within a PE, but the PE itself is not terminating, and I'm sure you're familiar, one of you would be familiar with my query. So we can't progress to the Form J or whatever the case may be because the fund still needs to continue. In a scenario like that, should we then rather just be paying out those members, or because it's a group, they had like a little store wherever that had paid out these members, or do you is there a process for a partial termination within the umbrella PE? Did you understand my question?
I'm trying to follow. So you are liquidate. You want to pay a certain number of members in a participating employer.
An application for a small group. Within an employer.
So that means some will remain.
That's right. The bulk actually remain. It was just that because of the size of the group.
No, it defeats the purpose of the liquidation. If you're gonna pay some and something remains in the fund or participating employer.
Yeah, because normally when a fund when it's a participating employer, it will mean that all members are terminating.
Okay. So even that ties in with that question that somebody had about the paid up benefits, because you can't, then you shouldn't be making application or partial applications on a PE within an umbrella. You have to terminate the entire employer basically. So you can't leave paid ups. You can't leave paid ups. You have to then give them the option to transfer out and then proceed with the liquidation. Am I correct?
That's correct.
Okay, thank you.
Thank you so much, Marilyn. There's another hand I cannot see. May you please unmute yourself, Mr. Van Rensburg? Miss Van Rensburg, please.
Yes, thank you very much.
Yes, Mr. Thank you.
I think my question falls under the unclaimed benefits. When you apply for exempt liquidation, then if there is unclaimed benefit, well, then you can't go that route, and you have to follow the non-exempt liquidation route where you appoint a liquidator. One can consider it sometimes unfair for the members to carry the cost and the long liquidation process for just because of one unclaimed benefit that could take a couple of months to resolve or transfer to an unclaimed benefit fund. I often get cases where I can go the exempt liquidation route. However, there's a pending death, and we all know that pending deaths could take months or years to resolve. And that then prevents one going the exempt liquidation route. And it also, for me, I consider prejudicing the members who could have gone the exempt liquidation route at much lower termination cost and in terms of timeline to get to the point where benefits can be paid. Your comments, please.
Yeah, I think it's very unfortunate because whenever there are unclaimed benefits, I think the Act requires that the accounts at least give the unclaimed members for the account to be advertised so that unclaimed members can come forward. But if we cannot just go straight and exempt from the liquidation, yeah, but I understand where you're coming from.
Thank you.
Thank you so much, Mr. Raseroka and Mr. Mabena. We can now open for questions and comments. I mean, if questions relating to liquidations come up, I mean, you guys should be able to attend to those. But going back to the chat function, we've seen that there are a number of questions. One question from Bekumuzi, I guess this is related to Johan's presentation. He's asking, can a registered type B fund re-register as a type A fund? If yes, how?
Thank you for that question. If a fund has been registered a type B umbrella fund, it can convert to a type A umbrella fund, but it doesn't re-register. It just amend the rules of the fund to make provision for special rules and all the benefits, pertaining to that. So a type B umbrella fund can change to type A umbrella fund, but the rules of the fund just need to be amended to make provision that the fund is now a type A umbrella fund.
Okay.
I hope that answers the question.
Yeah, for me, it provided me with clarity. Thank you, Johan. The next question is from Nestle. What does ceased to exist mean? Is this related to CIPC status? Some employers are in deregistration for years. What is considered evidence that employer no longer exists?
Yeah, thank you for the question. The authority cannot comment on the CIP status because we don't know what they mean by cease to exist. They could have a different meaning on cease to exist. So we just look at our guidelines and provisions relating to what we see as cease to exist. One example that I can give is where the participating employer never commenced, but special rules were registered, and the participating employer cannot be reach to complete the C4. Then we ask for an affidavit by the chairperson of the fund that detailing the steps that was taken to try to locate the principal employer. So in that affidavit, he will say we called, we sent emails, we went on site, depends on the situation, and on that we will consider termination of the participating employer, but it's all on a case-by-case basis. Thank you.
Okay, thank you, Johan. There's another question. It says, is there a requirement to also reflect the participating employer's trading name, as this is usually the name which members are most familiar with?
I think that's another question for me. We prefer that the CIPC name, just for example, ABC Shoes Pty Limited must be reflected. But if the participating employer is known by a trading as name, we prefer that it be included in the special rule. So it will be ABC Pty Limited trading as Big Shoes or Mini Shoes or something like that. But yes, thank you.
Okay, thank you, Johan. Another question, sorry. So when you consider special rules, registration of special rules, do you require them to submit registration certificates, CIPC certificates, before you register special rules?
No. It's only when there is a name change of the participating employer. We will ask for that Annexure C must be submitted and then proof of the name change. We won't just change a name on our system if there's no proof for it, but if it's a first set of special rules, we don't require that documents. But if, say, for instance, we could see that there was maybe a typing error where they just say ABCPTY in brackets and left out the limit, we can ask, why is that registered name? So we just have to satisfy us when we register the special rules that the name of the participating is correct. But just coming back to the first point, when it's the first set of special rules, we don't ask for that certificate.
Okay, thank you so much, Johan. There's a hand from Mr. Hupe. Mr. Hupe, please unmute yourself.
Thank you. Thank you for giving me time to ask these questions, because now we are just making a follow-up with regard to this liquidation process of the funds. This is Thomas Malokota speaking again from UBC. Now, the FSCA has made a comment that at least we need to have some specific evidence that can be put forward with the FSCA with regard to the liquidation process of some of the funds, or the question that we raised earlier on with regard to former members or members of that particular fund. The reason why we raised this is because we are coming across such obstacles in terms of members complaining that now there is a law or a section that says members should be are always referred to PAIA regulations, which at the same time, those were members who were contributing into that fund. Subsequent to that, the UBC is encountering problems when it comes to such members who are complaining about this. I can make an example. There is a fund, a mine fund, that was liquidated, that had assets in the amount of 40 million which already have been submitted with the FSCA. But then when one of the representatives of those former members, he was referred together with those members of that fund, they were referred to PAIA. Now, this is the question mark to us, that why are members referred to PAIA? And at the same time, we would like to know that are members or former members entitled to those assets or prior liquidation of that fund? Are members still entitled to have a share in that fund before liquidation? Thank you very much.
Thank you, Mr. Raseroka. Mr. Mabena, if you may. I know on the chat section, Takalani actually did respond to the PAIA comment that you made. I'm not sure if you've seen the response, but in the meantime, I'll just give Mr. Raseroka and Mr. Mabena if they can come in.
Sorry, Julia, can you summarize the question?
So his question is, when members require their benefits, they are referred to PAIA, I think, and I said that that question was attended on the chat box. I'm trying to look at it. And then his other question was with reference to liquidations. Mr. Kupe? Mr. Kupe? Mr. Kupe? Can you unmute yourself? Okay, we'll just wait for him to come back.
Hello, Julia.
Can you please summarize your question on the liquidation, and we'll attend to the PAIA one because it was attended to on the chat section. But can you just summarize your question on the liquidation part?
Yeah, look, basically what we are raising on the issue of liquidations is that in terms of the requirements for a fund or pre-requirements for a fund to be liquidated, there needs to be processes that needs to be followed. And one that we are very much aggrieved about is the objection to the liquidation, that as members, we are entitled to object. And in terms of objection, we need to follow a particular criteria. And we have met those criteria in more than 2 occasions. And those funds still went ahead and they were liquidated without even us being informed about the final decision in terms of or maybe get a response in terms of how has our objection been dealt with by the board or by the trustees. So this is the issue we are raising about liquidation, that it looks like the process is a bit unfair and undemocratic towards its terminal stages.
Thank you
and
so
the
much.
issue about the PAIA, the issue about the PAIA, it's simply we think some of the administrators are using the PAIA issue as a gatekeeping mechanism, just to dismiss people from claiming or making inquiries. And this thing about the PAIA, we must review this thing amongst ourselves and the administrators. It's unfair practice. Thank you.
Thank you so much, Mr. Raseroka, on member communication and objections being taken into account.
Yeah, I'm not sure when he speaks of objections, does he mean that they didn't want to are they objecting the liquidation process, or they just didn't want their fund to be they didn't want to be liquidated? They wanted to remain in the as members of the fund.
Mr. Kupe?
Yeah, look, our understanding is that you can't simply liquidate a fund that has assets and has members. And many administrators, they're saying they go the liquidation route because they are no longer members in the fund. And we have gone to an extent of proving to administrators that this fund is got members, and these are the members, and these are the companies they used to work for. And based on that, all that information and the effort we are making, the fund still gets liquidated. Now we're asking, what is the role of why is it that objections form part of the prerequisite to liquidation when in fact they are not considered? These objections we are making, they are not considered, because once you liquidate the fund, then those members and especially our members, the client we represent, are disadvantaged.
Yeah, I don't know, because sometimes the rules of the fund will provide when the fund will be liquidated. So I presume the board of trustees would have taken cue from their rules, and maybe they had reasons why they were they wanted to liquidate the fund, because it's not necessarily that the fund should have. In fact, I don't think the fund it should be liquidated if they don't have members. So funds that are liquidated should be having members, and the aim is to pay benefits to their members.
Thank you so much, Mr. Raseroka, and Mr. Kupe. I think, Mr. Kupe, if you want to take this further, I think obviously because it's something that you are well aware of, you can just communicate with our Prudential department, and we can talk it through. I see there's a hand from Mr. Kekana. Mr. Kekana. Please unmute yourself. Okay, maybe it was an ancient hand, or he just pressed that by mistake. So I see there's a comment. So Mr. Kupe, you'll take that up with our Prudential department. There's a comment from Marilyn, and this goes to Johan, and she's asking if the FSCA will consider similar sessions.
Sorry,
Yes.
Julia, it wasn't a mistake.
All right.
I was struggling from my side.
Okay.
I wanted to respond to Thomas' question regarding the objections. We had a meeting with them last week or so. They sent us an email proving that they objected to liquidations of 2 funds. And I guess my colleagues here are not aware. So I've just forwarded that email, Mr. Molokotsa, to the relevant department. They'll investigate and get back to you. I just wanted to make that clear.
Okay, all right. No, thank you so much. There's a hand from Zakir. Please unmute yourself. Tony, please unmute yourself. Zakir.
Hi, thank you very much for giving me the opportunity to ask the question. It's posed at Johan. Johan, when you were talking about the change from an umbrella B to an umbrella A, and the fact that we then make provision for special rules, what would happen with the existing participating employers on the umbrella B fund? Would we then need to do special rules for all of them? Going forward, would we have to revise the way we structure those?
Hi, Tony. Thank you for the question. A type A umbrella fund has special rules. So if a fund is converting from a type A umbrella, from a type B umbrella to a type A umbrella, all the participating employees who participated on the type B umbrella fund will have to have special rules drafted for them, and each one will have to be registered separately. So yeah, there is implications for converting a fund, a type B umbrella fund to a type A umbrella fund.
Thank you, Johan.
Thank you.
Was what I thought. Thank you.
Okay, cool stuff. Thank you.
Thank you so much, Tony. Do you want to say something before I continue? Ladies and gentlemen, please, while we're still on the line, we have less than 30 minutes remaining. I know that we're dealing with questions now, but please, can I ask that we go into the chat box? There's a survey that we all are required to obviously fill, complete, so that we can obviously get your feedback on how the session went. Tony? Before I move, do you want
Julia?
to? Yes, Kia?
Zakir, I don't think was able to pose his question. Can you unmute himself, and then the floor is his. Zakir, hello? Okay, all right. I think we can move on if that's the case.
Yeah, I think they're struggling to unmute themselves on the other side, yeah, for some reason. There's a question from Natalie. Other than the exemption in terms of Section 28, does the Pension Funds Act allow for, or is there an application available for exemption relating to the termination of participating employers, other than an exemption in terms of Section 28? Johan, Mr. Raseroka, Mr. Mabena? So the question is, other than the exemption in terms of Section 28, does the Pension Funds Act allow for, or is there an application available for exemption relating to the termination of participating employers?
So in terms of our templates are in Directive 4. So if you want to be exempted from liquidation, if I understand the question correctly, you will fill Form D. So you will get that from Directive 4. I don't know if I got the question correct.
Okay, no, thank you so much, Mr. If there are questions, I guess Natalie will raise her hand and ask further questions. There's a comment from Mr. Masiko, and he says, does the regulator have any links or knowledge of any pending ongoing participating employer liquidations so as to facilitate inclusion of any arrear contributions to the liquidation process and therefore safeguard interest of members? And what stops the 13A indebted company from liquidating, thereby clean their hands of it all? Mr. Raseroka, should I repeat the question?
Please repeat.
Very low. Yeah, so he's asking if do we have any knowledge of any ongoing participating employer liquidations so as to facilitate inclusion of any arrear contributions to a liquidation process and to safeguard the interest of members?
Yeah, I think, yeah, there are, if I understand the question very well, there are participating employers which are going through the liquidation process, which have got arrear contributions, and it's actually most of them that go through the liquidation process will be those with arrear contributions, because remember, they wouldn't have qualified to be accepted from the liquidation process. So I don't know if that answers the question.
So will there be anything that stops a 13A indebted company from liquidating? So if we realize that an employer has got arrear contributions, how does that affect the liquidation?
No, we cannot
impact
stop.
On the liquidation?
We cannot reject the liquidation application because there's arrear contributions.
Okay. All right.
Naturally.
Thank you so much, Taki. I see your hand is up. Please unmute yourself.
Sorry, I thought maybe, and the person who asked the question in the chat might then just clarify that that's what they meant. But I understood the last question to be, if we did receive a liquidation application, do we have any way independently of knowing whether that employer is actually in arrears, right? But that would, I suppose that would mean that the administrator, I don't know how it would be possible, but do we have any way independently of knowing when they are employers that are in arrears, so that we don't liquidate, meanwhile, that employer actually owes the fund? And then I suppose that last comment about then clean your hands, and then you technically get away with not having to pay that debt. That's how, unless I misunderstood it and the person can then clarify, but that's how I understood the question. Sorry.
Okay, thank you. So thank you. Mr. Raseroka, do you want to come in? The question was asked by Mr. Masiko, so maybe if Mr. Masiko can come in, if he's still here with us. Okay.
What I just want, please, Tagi, can you clarify again? I think I missed some of the thing that you said there.
Yes, so Mr. Mashko has then confirmed that, yes, that's the correct question. So if we receive an application saying we want to liquidate this participating employer, is there some way where we can check, independent of what we're being given by the fund, that that employer doesn't have arrear contributions?
Yeah. I think from a regulator point of view, we rely on what the fund, the information that the fund supply gives us. Like it's utmost good faith that they'll provide us with the correct information. So there's no other way we can, unless if we have received any communication from a third party or somewhere that they are actually at a contribution, then we can follow it up.
Thank you so much, Mr. Raseroka. The next question is from Nadling. It says, is there any way that a chairperson, I think it's directed to Johan, is there any way, Johan, that a chairperson can delegate responsibility for completion of declaration to another board member or PO?
Thanks for the question. Short answer is no. The only delegation is from a principal officer to a deputy principal officer in terms of the act. So no, it cannot be done. Thank you.
Sorry, Johan, can I just ask, are we talking about declarations for the registration of participating employers here?
I don't know. I think it was just a general question, but the chairperson cannot delegate his functions to somebody else on the board. He's the chairperson, so he cannot delegate his functions as chairperson to somebody else. So it's only the PO that can delegate some of his functions to a deputy principal officer.
Okay, so
yeah.
Yeah, so thank you so much. The next question, I think it's also related to that, but maybe Nestle can come in just to give us some clarity. It says, can the fund sign instead of the employer, where we cannot reach the employer for signature in order to process claims to members?
I think.
Oh, sorry about that.
Can you? No, sorry, Johan. So I thought Julia wanted me to confirm Or do you need me to clarify the question?
I think, just clarify the question, please, if
Yes,
you don't mind.
please.
Thanks.
Okay, so in terms of the liquidations process, it says that once we've exited all members, then we can go for the exemptions process. To exit all the members, one of the requirements is that the employer verifies that that's the member, right? So it's a stamp and a signature. There's a practice for some funds where the peer will sign instead of the employer because we can't reach them or find them or they no longer exist. Is that an acceptable practice or is it not?
Yeah, that I would say no, because is there any delegation documentation being signed for that specific? Because it gets certain documents needs to be signed by certain people, and if I understand correctly, it relates to liquidation documentation. Does that need to be submitted to our Prudential department, or is it just in terms of
Sorry, let me clarify. So the actual claim forms, my interest is in the member, right? So the member can't find the employer and neither can the fund. But we've got a fund credit. We're holding a fund credit for the member and he's trying to exit the fund. We haven't liquidated the employer's participation yet because it still says AR deregistration. We're not sure where the employer is. So we're trying to establish whether the fund can sign instead of the employer just to pay the member's claim.
Thank you, Nestle.
I think it depends on the claim that is being processed. So I think Takalani, if you want to add to something, I would appreciate.
There's a hand also from Usluria.
Yes. Sorry, Nestle. So the claims process, especially when it comes to verifying who are you paying, from our side, we don't have a requirement for, as Johan is asking in terms of what should actually come to our office. The most important thing is for the fund to then be able to determine that they're paying the right person. So for me, a claim form signed by the member, right, would be sufficient, since you have the employer's details and you know for a fact that that member or that employer is no longer in existence and this member is due their benefits. I think it would qualify almost in the same way as unclaimed benefits. There's no, and we've heard about delays where members are told to go and find the employer and get the employer to sign a form. Meanwhile, it doesn't actually add any value to what benefit you're going to pay them and to your own process for verifying that that is the member that you're paying. So I think we just need to be, it might be almost an unclaimed benefits discussion, but it is a payment discussion that we do need to be a little bit more flexible in terms of what would be acceptable, because, to delay making the payment where an employer, one doesn't exist anymore, or, doesn't care about the process anymore because they themselves are in liquidation. As the administrator, you are sitting with the information and are able to verify that, this is the member based on the documents that are submitted, and you've already got the contributions, and you've got all the information. Remember, your obligation in the instance of the rules is to that member and their fund credit. So the processes you design need to also be reflective of that. Thank you.
Fantastic. Thank you very much.
Well, thank you, Takalani. Thank you. I appreciate it. Thanks.
Thank you so much. There's another question from Mr. Coupe. Johan is asking about cancelled funds. When will the FSCA, and I guess this is directed to the FSC and the retirement funds. So about cancelled funds, when will the FSCA and fund administrators reinstate them? I'm not sure if this was answered or there was a comment, Tagi.
Yes, again, based on Mr. Kakana's comment, we did have a meeting with the UBC, and we have been providing information on the cancellations project and also on the list. So this would not necessarily be the appropriate forum. And on top of that, we actually had already provided the information. So I'm not sure whether there's anything outstanding on that part, but on our side, we'd already provided all the information to the UBC.
Okay, thank you so much. I'm not sure if there's anybody who wants to ask a question. If maybe I didn't see your comment or your question, this is your moment to ask your question. Without any waste of time, if there are no hands, ladies and gentlemen, we've reached come to the end of the webinar. Thank you so much to our speakers for availing yourselves today and sharing your insights with us. And thank you to obviously the organizing team for making sure that the webinar becomes a success. And lastly, thank you to the attendees for, okay, there's a question from Mr. Kupe. Yes, Mr. Kupe, you've got 2 minutes. Please unmute yourself. Mr. Kupe? Okay. Kia, are you able to hear me? Kia?
Hi, Julia.
Are you able to hear me?
I think in the interest of time, you know, if Mr. Kupe and his fellow colleagues they have anything to raise with the authority, they please write to us.
Okay.
Just use that forum. Yeah.
All right. No, thank you so much. And lastly, to everyone who attended, thank you for making time to be here and thank you for the engagements. We hope that this was informative. Like Marilee said, they're looking forward to future sessions or engagements with the authority. Please, before you leave, make sure that you complete the survey so that we can hear your comments and your inputs so that we can improve going forward. And as previously stated, the presentation will be made available on our website and the recording will be available on the FSCA YouTube page. And thank you so much from me, Mampi Julia Masike. I hope I see you in part 2 of our webinar. Thank you so much. Please make sure that you complete the survey.
Thank you, everybody. Bye.
Yep.